Hi everyone, welcome back. This video will be on developer and strata owners. We're going to touch on the roles and duties of both parties, the developer and strata owners. And we are going to divide this video into 4 parts. The first one will be roles of both developers and also strata owners. Second one will be the duties and powers of developers. The third part will be on the duties and rights of owners. And the fourth part will be on bylaws and additional bylaws. Now, the learning outcomes of this video can be divided into 3. At the end of watching this video, you should be able to understand the roles of both developers and also owners. And then you should be able to understand the duties and powers of developers. And then finally, you should be able to understand the duties and also the rights of strata owners. And these are very important because most strata disputes are caused by failing to understand each party's roles and duties. And we will see later on the implication of failing to understand the duties and the roles, and also what happens when developers, for instance, do not know the powers afforded to them by the SMA and STA. Now, it's important for you guys, okay, to be familiar with these short forms or these acronyms. Yeah, you will encounter these acronyms again and again in this course. I think I have already exposed you to some of these before, but for now, I think if you are not familiar, what you should do is you freeze the video, maybe take a note, take down some notes. Yeah, jot down what is DLP, DVP, DMP, PMP, STA, SMA, SMR. Yeah. Okay. But of course, in the slides, an explanation will be given. But it's good for you if you are familiar with the short form by now. So we go to the first section, which is the roles of both developers and also the strata owners. Now, before we learn about the roles of the developers and also strata owners, first of all, we need to be familiar with the definitions of developer and also strata owner. Now, according to Section 2 of SMA, developer means any person or body of person. So that means that it can be a natural person and it also can be a company, yeah? By whatever name described, who develops any land for the purpose of residential, commercial or industrial use, or a combination of such uses. Now, we are familiar with apartments, with condos, so that is under residential purpose. But as I highlighted a lot of times, yeah, in our lecture, strata properties can also include commercial properties such as strata office, yeah, industrial factory strata, yeah. Combination, as what we're going to learn later on, we have integrated mixed-use strata. In relation to subdivided building or land includes the original proprietor of the lot before subdivision. So that means that, okay, before application for subdivision of the building, okay, maybe you have the developer being the proprietor, the landowner. So this will also include the definition of developer under SMA section 2. And also, okay, under section 2, developer also means or also includes the executors, administrators, successors in title, and liquidator. Now, don't worry. Okay, this is the next slide will show you. Yeah, the explanation of executors, administrators, successors in title, and also liquidator. Now, who is an executor? An executor is the person or body that handles a deceased person's estate, making sure all property is distributed according to the decedent's wishes and that all debts are paid. Now, simply, when a person is deceased, okay, you need to take care of the estate lah. Maknanya untuk distributekan the harta lah kepada waris-warisnya kan. So, executor is the person who makes sure that property is distributed according to the wishes. Meaning, if there's a will, okay, then that's how the estate will be distributed. Decedent means the deceased person, yeah. Administrator is the person who manages an insolvent company. Again, insolvent means company yang dah illiquid lah, almost bankrupt ataupun dah bankrupt. So, administrator is the person who manages an insolvent company. Company yang dah tak viable, dah illiquid, tak ada cash. Successor in title is anyone who takes over the legal ownership of a property from someone else. So means that a buyer buyer of the land, for instance, developer dia transfer, dia jual dia punya business, for instance, to another company. So successor in title means the new owner lah of the business, the new developer lah, takes over legal ownership. Now, liquidator is the officer appointed when a company goes into winding up or liquidation, who has responsibility for collecting in all the assets, under such circumstances, okay, and settling all claims against the company before putting the company into dissolution. So means liquidator tu orang yang step in ataupun a body. Now here it says officer lah. Officer tu representative of the organisation, okay, yang akan be in charge of managing the insolvent company. Maknanya dia yang jualkan aset, settling for the creditors, bayar hutang dulu, okay. So these 4 categories, executor, administrator, successor in title, and liquidator, are also developer, per section 2 SMA. Now we go to the definition of strata unit owners. Now, according to section 4 SMA, okay, parcel owner is the purchaser or the developer in respect of unsold parcels in the development area. So that means that the first category is very straightforward. The purchaser is the parcel owner. The buyer of the parcel in a strata scheme is the owner. Straightforward, But another category of owner is the developer in respect of unsold units in the development area. So that means that if there are unsold units, units yang tak boleh dijual lah kan, unsold units, the developer will be the owner who has to bear the duties and also the responsibilities lah of the owner. So whatever the duties of the owners, the developer has to bear the burden. Okay, selagi mana the units are unsold. Now says there, this is quite important, the purchaser becomes parcel owner or strata proprietor after the perfection of memorandum of transfer, MOT. So means that when a person purchases a parcel, he is not yet the owner. The ownership is only perfected, is only completed among perfection of MOT. Maksudnya bila dah register, upon registration. So that means that merely signing the SPA does not make one a strata owner in terms of completeness lah. You need to finish the process. In this case, you need to perfect. Dia panggil perfect. The process is known as perfection of memorandum of transfer, perfection of MOT. MOT, okay, is normally the form 14, borang 14A, form 14A, sama dengan National Land Code, same as what we've learned before under land law. Please bear this in mind, when you sign the sale and purchase agreement, okay, your ownership is not complete yet, okay, must be perfected. Dia kata perfected by registration. Mesti register dulu, barulah you strata unit owner under the eyes of the law lah. Tapi maknanya you dah sign SPA tu, of course you are given the rights of an owner lah, but it's not perfect yet. So maknanya remember what we talked about in land law before, dia ada equitable rights lah kan, masih ada rights but not perfect yet. Okay, mesti register dahulu. Strata title allows individuals to own or co-own part of a multi-story property. Kata di situ to own or co-own part of a multi-story property means that one parcel can have two owners, no problem, same as land under National Land Code. So the way is by subdividing the building into individual parcels. Inilah strata title. The concept of strata title is building subdivision. Then it says there, at the same time, strata owners have shared ownership of the remaining areas of the property. So anything outside the parcel, outside the accessory parcel, outside the provisional block, itu semua adalah common property. Means everybody owns lah, kan? Nama dia pun common property. So what does this mean? strata owners, dia kata, are persons who own one or more parcels within a strata development and are joint owners of the common property within that strata development. So, the strata owners adalah person, natural person, okay, it can also be company, doesn't matter, okay, who own one or more parcels, yang memiliki petak satu atau lebih satu petak di dalam strata development. Okay, so the parcel is individually owned, but at the same time, the owners are also joint owners. Mereka juga pemilik bersama, joint owners of the common property within that strata development. So they own two things. One, the strata, individual owners, they own the parcel individually. They are also joint owners of the common property. So ownershipnya ada dua, satu kepada parcel, satu kepada common property. Now, if that's the case, kalau kita kata strata owners own the parcel and also are joint owners of the common property, strata owners are responsible to maintain and repair his parcel and accessory parcel. So, parcel maknanya the petak, the apartment, the office strata, the factory strata tu, itu dia punya responsibility. Accessory parcel attached to the parcel, contohnya storeroom, aircon ledge, ataupun apa yang kita selalu bagi example, parking car park kan, parking bay tu, itu under the responsibility of the owner to maintain and repair. At the same time, the responsibility is to jointly manage the common property, land, lift, corridor, staircase kan. Kita cakap pasal landscape, itu semua responsibility of all owners, jointly managed, to be jointly managed, untuk diuruskan bersama. Strata owners, so in this case kita bolehlah, we can also describe the strata owners as shareholders of a public listed company, of which the management body takes mandate from. So maknanya dia adalah satu syarikat yang mana the parcel owners are the shareholders kan. Itulah timbulnya share units tu. Okay, share units tu. Sebab kita sekarang ni berada dalam satu company. The strata scheme can be regarded as a company, or even in some literature they call the strata schemes as government pula, that mini government, because you have rakyat, you have people, you have the population, the strata owners who have to live together, they have to uruskan tadbir kan, they have to govern their own strata scheme, and who has to govern, who has to administer, siapa yang uruskan is the perbadanan pengurusan lah, the management body lah. So what is the relationship between developers and strata owners? Okay, developers are seen as the expert in the maintenance and management of the strata development as they oversee the design and construction of the development. Okay, because developers are the ones who plan, who design, who oversee the construction of the strata scheme, they are seen as the experts of the strata scheme. Bila dia dah expert, dia dah tahu the ins and outs, the operation of the, macam mana the strata scheme should be managed, should be maintained, they are the expert in the M&M lah. So therefore, okay, the STA and SMA, they involve the developer in the early maintenance and management of the development. Semasa baru siap tu, both acts, STA and SMA, okay, they feel that the developer is the right party to handle the new strata scheme, because they know the scheme better than other parties. Okay, but having said that, it cannot be expected for developers to maintain and manage sampai habis kan, sampai the development sampai bila-bila. There needs to be a point in time where the M&M of the strata scheme is passed on to the next management body, either the GMB ataupun the MC. Now, the delivery of vacant possession signals the period where the developer is responsible for M&M until the formation of the next management body, either GMB or MC, depending on the situation. So, the starting point, TO, T kuasa, bila start of the maintenance and management of the strata scheme is upon the delivery of vacant possession. Serah kunci saja, terus saja developer will be entrusted to be held responsible for the maintenance and management of the strata scheme. Okay, and it says there until the formation of JMB or MC. Ini we will learn later on. Okay, when we talk about the management bodies tu. Kenapa ini terjadi? Why is this or? Kenapa ada perkataan or? Kenapa tidak katakan formation of JMB sahaja ataupun formation of MC sahaja? Because there will be a condition, okay, that must be fulfilled before you can decide ataupun before the next management body punya type, the next type of management body is decided. It depends on a condition. So if the situation leads to JMB, this developer punya management period ni is known as developer's management period. Okay. Now, as we said before, delivery of vacant possession, then kena start maintain and manage the strata scheme. The first party to manage and maintain is the developer. Okay, the period tu, the nama period tu depends on the next management body. If the next management body is the JMB, developers punya period tadi tu, M&M period, is known as developers management period, DMP. If the next management period following the developer just now is the MC, the developer's M&M will be known as preliminary management period. So itu beza dia. There are two terms for the developers punya period. Okay, satu DMP, developers management period. The other one is PMP, preliminary management period. It all depends on who is the next management body. Siapa badan pengurusan seterusnya. Kalau JMB, then the developers punya M&M is known as developers management period. Kalau the next management body is the MC, okay, the developers M&M is known as preliminary management period. Now, if that's the case, apa-apa pun yang jadi, tak kisahlah sama ada the next management. It doesn't matter whether the next management body is the JMB or the MC. This trend ataupun this system, okay, shows you, okay, that the M&M of a strata scheme is first of all developer controlled, then it will hand over or it will transfer the responsibility to manage and maintain the strata scheme kepada owner. So daripada developer kepada owner. Itu dia punya what you call the principle lah. Prinsipnya ialah developer dahulu, then barulah the next management body, which is owner controlled. Daripada developer kepada owners. So the next section will be on the duties and powers of developers. So let's understand more on the effect of delivery of vacant possession on strata management. It says that management of the strata development starts at the delivery of vacant possession. So we can see that the delivery of vacant possession triggers the management of strata development. Itu starting point dia. DVP saja, startlah the management of the strata development. So what is DVP? DVP, delivery of vacant possession, refers to the property handover process, where the bare house and also other buildings, not just house, any other fittings and furnishings listed in the SPA are given to the purchaser upon completion of the conveyancing process. Conveyancing tu proses pindah milik tadi tu, whereby the owners will receive the keys to their units. Serah kunci. That's why the layman's term for delivery of vacant possession is serah kunci. Ataupun the Malay equivalent is serahan milikan kosong. Okay. Now for specifically for newly developed residential strata, apartments, condos, the DVP is 36 months from the SPA signing. So upon signing of SPA, developers are given 36 months to deliver the vacant possession of the parcel, of the condo, of the apartment just now. Tetapi as what I explained in class, sudah ada case law yang further refine. Dia refine balik apa maksud signing tu. Is it the SPA itself ataupun booking fee paid? Says their case laws have stressed that it may begin. 36 months tu mungkin boleh bermula. It may begin from payment of booking fees. Yang pergi apa, kalau ada house buyer campaign kan, house buyers campaign mana-mana dekat kompleks, shopping complex tu, whereby you sign a booking form and then you pay a little amount kan as a booking fee. Itulah, that is the start of the 36 months. So dah ada beberapa case laws yang yang tunjukkan bahawa once you sign the booking form and pay the booking fee, the clock starts ticking for the developer to deliver to you rumah yang dah siap. It is specifically hanya untuk rumah saja, untuk residential strata only, ya. Because for other types of strata development, tak ada statutory sale and purchase agreement. For residential strata, kita ada what is called statutory sale and purchase agreement, Schedule H of HDA. So it says that, for residential strata, DVP triggers strata management by the developer, and it's this period, Okay, one way to ensure proper maintenance and management by the developer during DMP and PMP is by creating what is called Common Property Defects Account, CPDA. So CPDA ni is an account created yang mewajibkan developers to deposit a certain amount of money, and then that money inside the account can be used to claim against the repairs for the common property kalau ada defect during the developers management period ataupun preliminary management period yang coincide, yang in cases of in most cases akan coincide, akan apa kita panggil tu, kebetulan. Dia sama pula dengan defect liability period. So defect liability period bersamaan dengan developers management period or preliminary management period. Then ada satu tabung khas, ada satu account khas yang developers kena masukkan duit, okay, untuk ensure proper management maintenance, and it's known as CPDA, Common Property Defects Account. Now, first of all, developer shall give a written notice to COB of its DVP intention 21 days prior to the DVP. So sebelum nak serah kunci, before the before the delivery of vacant possession itu, developer must give notice to COB of its intention. Niat dia tu, niat dia akan deliver the vacant possession 21 days from this notice. Dia ada syarat tu. So 3 minggu sebelum kejadian, 3 weeks before the delivery of vacant possession, the developer must give notice to the COB yang dia akan serah kunci 3 minggu lagi. Together with the notice, the developer will also attach a certificate of the estimated cost of construction. So berapa cost of construction for that particular strata scheme? Berapa duit yang dah di-spend untuk for instance foundation, untuk infra, untuk M&E, mechanical and electrics kan. So all those, semua kos-kos berkaitan dengan construction, excluding the land cost. Land cost tak termasuk dalam ni. So the cost of construction saja. The certificate is prepared by the submitting person ke which is architect ataupun engineer. Dia akan certifykan berapa estimated cost of construction. So two things tu kena submit kepada COB dahulu. So this is per regulation 46 of Strata Management Regulation. COB upon receiving the notice and also the certificate of cost of construction cost just now, they will determine the amount of deposit of CPDA just now. Berapa amount yang patut dimasukkan dalam CPDA for that particular new scheme. Either 0.5% cost of construction or 50,000. Mana yang lebih tinggi? So dia akan calculate, okay? From the construction cost just now, dia akan calculate 0.5%. Dia akan tengok sama ada 0.5% of the cost of construction, is it higher or lower than 50,000. Kalau higher than 50,000, dia akan ambil that amount, which is 0.5% tu of the cost of construction. But if the 0.5% of the cost of construction is lower than the the 50,000, dia akan kata minimum amount yang kena deposit ialah 50,000. Okay, so this is regulation 47 of SMR. This money, this deposit is paid to the COB. Mestilah dibayar kepada COB. Sama ada either in cash or bank guarantee. Boleh pergi kepada bank dan minta bank guarantee lah. Bank boleh buatkan untuk you. Okay, bank guarantee tu dia punya syarat you kena ada certain amount dalam bank, and then I think so lah, as what I understand, and then the bank dia boleh keluarkan satu bank guarantee yang mungkin dia punya nilai tu lebih daripada your deposit in the bank account. Sebab ada track record kan, ada financial record you dengan bank tu, yang dia boleh guarantee kan, yang mana dia yakin untuk guarantee kan you punya deposit tu. So this deposit is paid upon DVP, upon delivery of vacant possession. So developer tu adalah masa untuk prepare 3 weeks just now, the amount tu. Okay, this is regulation 48 SMR. Then COB akan masukkan deposit itu ke dalam common property defects account, CPDA just now. Okay, for each development akan ada satu CPDA. So this is regulation 50 SMR. Now again, SMR is Strata Management Regulations kan. That's why it's not section ya. Kalau dia adalah peraturan, regulation, okay, dia tak panggil section 50, dia panggil peraturan 50. So in this case is regulation 50. COB may utilize the deposit for the purpose of carrying out any work which is necessary to rectify any defects in the common property of the strata property of the strata development. Nama pun common property defects account. So duit dalam account tu hanya boleh guna, can only be used to rectify defects in the common property. So going back to the responsibility of M&M just now, kalau ada kerosakan dalam parcel itu tak boleh guna CPDA. Itu kena claim lain. Kalau masih under defect liability period, the owner boleh claim dengan developer under defect liability period tu, bukan under CPDA. Developer kena out of pocket lah, kena gunakan duit dia sendiri. Okay, so this one is only for common property only. Again, siapa yang tak sure lagi, go back to what is the definition of common property. Dah berbuih mulut cerita apa tu common property. Okay, bukan pasal dia common property saja. CPDA is only for the to rectify, to repair the damage, the defects di common property sahaja. Apa-apa yang berlaku dalam parcel, dalam accessory parcel, itu tak di cover, tak tertakluk, it's not covered under CPDA. Now it says that during the defect liability period, claims can be made on the account by purchaser or owner. Again, kat situ ada dua kan, purchaser itu orang yang dah sign tapi not perfected yet, belum transfer lagi, belum register lagi, bukan transfer, belum register lagi kan, belum ada, belum perfection of transfer just now, not done yet. That's why dia masih purchaser. Eventually purchaser tu akan become owner lah. Okay. JMB, MC, sub-MC. Ini semua adalah management bodies yang ada. Kalau still tertakluk di bawah defect liability period, bolehlah diklaim by the management body kepada CPDA. Managing agent pun boleh claim. Okay, managing agent appointed by the commissioner, by the COB. Okay. Any interested person with approval by the commissioner. Interested person, orang berkepentingan. Contoh, contractors contohnya. Kontraktor yang buat kerja kan. Lepas tu dia pun minta lah claim daripada CPDA. Boleh. With approval lah, dengan kelulusan daripada Commissioner of Building. So what are the preparations that must be undertaken by the developer for dia punya management period tu? Mestilah dia bersedia dulu kan. They must do some preparations. They must be prepared to do these things. Barulah ada proper M&M of the strata development. So first of all, mesti review budget. Ini kan what we learn in class. First of all, untuk determine the charges, the contribution tu, mesti ada budget yang adequate. There must be a sufficient budget. Budget tu mesti cover semua tu. So ensure the maintenance charges sufficient to pay for the M&M expenses. Mesti review budget tu, kena buat budget betul-betul. Okay. Then the next one is to open bank accounts. Bila dah buat collection kepada charges, kepada sinking fund, mesti masukkan ke dalam account. The collection must be deposited in the correct bank accounts. Again, ada 2 accounts, one for each. Satu untuk charges, maintenance charges. Satu lagi untuk sinking fund. Mesti ada 2 account. Section 10, Section 11. Kan? That's what we learn. Now, open the bank accounts. Must open bank accounts, one for maintenance and one for sinking fund to deposit all collections. Set up the administrative office. The pejabat pentadbiran mestilah disediakan. The administrative office must be physically prepared. It must come together with telephone. Mesti ada line tu. Telephone line, mesti ada internet, furniture, computer, printer, software, itu semua. So, it's quite common nowadays to use software. Dulu-dulu pakailah Excel. But nowadays dah ada accounting softwares, property management softwares. Ada many types of property management softwares available nowadays. Dia bukan new. It's not new anymore. Semua orang pun dah pakai softwares. Okay. Then plan the procurement of the M&M services. Procurement ni untuk dapatkan tender lah. Dia dah proses tender untuk dapatkan cleaning services, untuk dapatkan security services, landscaping itu. Itu semua untuk decide first of all to do in-house ke outsource. That's why dia kena plan tu. Kalau in-house pun mesti dapatkan staff kan. They must get the enough adequate number of staff to do cleaning, security, landscaping kan, semua tu. Kalau nak buat outsource pun sama, which company, berapa clean staff, number of staff needed. So kena plan for the procurement tu. Macam mana cara tender tu, macam mana nak di open di mana, plan for the procurement. Related to one above, as I mentioned, procure the manpower, staff. Kalau in-house kena, okay, once you dah recruit, don't forget, the developer kena train. There must be a training. Lepas tu prepare the KPIs. KPIs tu supaya kita boleh ada performance indicators. Mesti boleh benchmark dia punya performance. Nak tunjuk kat orang tu perform ke tak melalui KPIs lah. Key Performance Index So maknanya for instance for maintenance kan, dikatakan all complaints not all tak boleh. All tak boleh. 80% complaints to be resolved within 24 hours or 48 hours. Itulah KPI dia. Okay, yang mesti di-setkan dulu. Barulah pekerja tu tahu apa yang nak di-achieve. Okay, so kalau in-house kena recruit, train and prepare the KPIs. Kalau outsource, in-house tu maknanya sendiri buat. Outsource means you use outside punya services. Okay, outside punya contractor. So, if outsource to recruit the service providers. And it's very important here, untuk developers, they cannot enter into any long-term contracts. Tak boleh. Kontrak tak boleh lama-lama. Sebab kalau developer is followed by JMB, developer tu hanya 12 months saja berada dalam sistem, berada dalam maintenance and management, M&M. Dia ada 12 bulan saja untuk manage the strata property, strata development. So tak bolehlah buat kontrak yang lama, sebab kontrak yang lama akan ikat the JMB. So that's not allowed. Okay? Sebab once the developer dah transfer the management power kepada JMB ataupun MC, mana nak enforce contract tu macam mana kan? Sebab developer is no longer the management body. So contracts signed by contracts ataupun agreements dengan developer dalam tempoh dia punya pengurusan must not be more than 12 months. Mesti short term saja. Tak boleh lama-lama. Okay. And then, okay, not only train the staff, cari staff, recruit staff, train the staff, cari service providers, mesti juga ada SOP tu, ada Standard Operating Procedure and Operations Manual. SOP dia kalau kata untuk visitor macam mana, untuk security guard dia punya ronda tu kan, the rounding of the surveillance by the security guard tu. Macam mana dia punya round tu? Is it once every 2 hours, 3 hours ke? Itu SOP dia. Dan mana dia punya check-in points kan? Itu semua kena set up. Okay? Kalau ada visitor management system, VMS is very very common nowadays to have VMS yang elektronik punya, yang dikawal secara elektronik daripada gate depan. So VMS, kalau visitor datang tanpa, for instance, not informed by the
or not authorized visitors lah kan, datang untuk visit, macam mana cara dia nak stop dekat guard, what is the procedure for them to stop at the guard house first, obtain a pass first kan, all those things. And then what kind of parking provided for the visitors, is it only for 1 hour, 2 hours, itu semua. Okay, time attendance system. So semua tu kena prepared by the developer. Then okay, open now. Tricky sikit. So sini nama dia dalam akta namanya register. Open a register of strata unit owners and share units. This register is not PTG register. Bukan ini bukan pendaftaran PTG, ini lain. Ini juga known as strata roll ya. So dekat the strata development itu, developer perlu ataupun not developer is the first one lah. Selepas tu the next GMB, the next management body. The management body tu perlu ada satu list, perlu ada satu daftar of all the owners, share units, details of the owners, alamat dia macam mana, contact number dia macam mana, okay? Semua tu perlu ada on site. Bukan di PTG. PTG tu lain. PTG tu for pendaftaran. PTG is for registration, yeah, of the strata title, for the transfer, for the caveat, semua tu. Semua matters tu is at the PTG. But here on site, di strata scheme tu sendiri perlu ada satu register, satu buku daftar, okay, of all the strata unit owners and the share units. Ini nama strata roll, jangan confuse ya. Nanti confuse pula. Nanti kita tengok 25% tu bukan here, bukan register ini. 25% punya magic number tu is based on PTG punya transfer. Hopefully you all tak confuse lah. Ingat ada dua register, satu dekat PTG, satu lagi dekat strata scheme tu sendiri yang simpan dekat, which is being kept at the management office and it's known as strata roll. Tolong ingat, tolong jangan confuse. Now then okay, prepare deposit for CPDA just now. So itu responsibility dia. So again dia ada dua formula, either sama ada 0.5% of construction cost or 50%, whichever is higher. So ini semua adalah preparation of the developers for the developer for the management period. Now here I want you to freeze or to pause the video and then to read these two items. One, bank accounts. Two, procure manpower or staff. So what happens during the developers M&M? Okay, what to expect, yeah? The first bill of service charge and sinking fund will be received by the owner shortly because they need the money, yeah, to do the proper M&M of the strata scheme. So dapat saja kunci, setelah kunci, the next thing to be expected is getting the invoice for service charge and also for sinking fund contribution. And the next management body after the developer depends on whether 25 or more allocated share units have been transferred to respective strata owners within the 12 months. So inilah the condition. So this is actually the important condition, the magic number, okay, that we're going to explore in more detail, okay, in the lecture on management bodies. But the condition is, okay, 25% or more allocated share units have been transferred. Maknanya strata title yang initially, at first strata titles will be issued on the name of the proprietor or developer, depending lah. So if the developer is the if the developer is the landowner, dia ialah proprietor. But if there's is a joint venture, then proprietor tu nama lain kan. But first issue of strata title will be on the name of the land proprietor. Then okay, the buyers, the buyer tadi kan dah beli, dah sign SPA tu, the buyers will have to change the name lah. The buyer's name will have to appear on the strata title. So this process is known as transfer kan. Dia buat perfection of transfer just now. So if there are 25% or more transfer, perfection tu dah siap, okay, dah tukar kepada nama pemilik baru, then only you can decide whether to have JMB ataupun to have MC. So inilah condition dia yang cakap, yang selama ni cakap. So it depends on the 25% within the 12 months time. Within 12 months. So kalau tak berjaya untuk dapatkan 25% tu, the next management body will be JMB. So if tak dapat 25%, the developer has to hold the first AGM for the JMB. Because the next management body is the JMB. So to create or to form the JMB, the first AGM of the JMB has to be held first. Ini syarat dia. Okay. The M&M under developer at this, if this is the way or this is the condition whereby JMB is the next management body, this period is known as developers management period. Yang dia cakap tadi lah in the previous slide, and is governed by sections 9 to 16 of SMA. This section dia lain. PMP dengan DMP section under SMA different. Yeah. So if manage to transfer 25% or more of the allocated share units kepada respective strata owners, the respective buyers, okay, the developer has to hold the FAGM, the first AGM of the MC. Okay, so maknanya sebab dia dah berjaya transfer dalam masa 12 bulan tu, you have the strata titles are issued in the name of the buyers. Okay, dan the corresponding allocated share units kepada the newly issued strata title tu is 25% or more daripada total allocated share units, then MC bolehlah ditubuhkan. And how to form the MC? The first AGM, FAGM. The first AGM of the MC has to be held. Barulah MC boleh ditubuhkan, establish secara formal, secara official. And the management and maintenance by the developer untuk period yang mana the next management body is the MC is known as the preliminary management period, PMP. The sections are 47, 55 of SMA yang akan govern the preliminary management period ini. So there's a slight difference. Okay, sebab DMP tu, developers management period, is the precursor ataupun satu period yang mana the next management will be a combination of developer and the owner, which is the JMB. Tapi untuk second situation, the PMP, preliminary management period, is a situation whereby developer akan manage, the next one will be totally on the MC, totally on the owners by way of MC. So that's why ada section lain-lain, ada kelainan dia. Yang satu situation tu, the first one, whereby the next management body is JMB, maknanya developer masih campur tangan, masih ada role to play in the M&M, kan? Sebab dia ada joint management body, maknanya joint tu maknanya a mix of developer and owners yang akan manage the strata scheme. MC maknanya cuma owner saja, developer dah tak masuk campur. Kecuali, jangan confuse, kecuali kalau kata developer tu adalah owner of the parcel, boleh lah. Now it says that normally management under developer coincides with DLP, defect liability period. Under HDA, DLP is 24 months from DVP, kan? After delivery vacant possession, dia ada satu guarantee period, warranty period known as the defect liability period, kan? And the defect liability period is 24 months from DVP. But the defect liability period for other types of property, commercial property, industrial property, depends on the contract. Sebab dia tak ada lah satu akta yang nyatakan inilah tempoh defect liability period. There's no specific act that mentions for other non-residential strata. Non-residential strata, berapa tempoh dia punya defect liability period. Okay. So the statutory defect liability period for residential property is 24 months. So pakailah 24 months for residential strata. Okay, this slide will discuss in more detail the process ataupun the meaning of the 25% transfer of strata title that was mentioned in the previous slide. So it says that when strata titles are issued, first issued, they will be on the name of the original proprietor, either the landowner lah, either the developer kalau mereka dah beli tanah tu, if they develop on their own land. Kalau JV maknanya ada another proprietor. The strata titles must be transferred to purchasers. Yang dah sign sale and purchase agreement, itu purchaser. Yang nama dah appear atas title, itu owner. Itu difference dia. So, the strata titles must be transferred to the purchasers for the purchasers to become owners lah. And this process is known as conveyancing. Process of transfer ini dikenali sebagai conveyancing. And the lawyer will use the Memorandum of Transfer, MOT, normally Form 14A. Again, Memorandum of Transfer adalah satu dokumen, is a document that allows for the ownership from the previous owner to be transferred to the new owner. So, nama dia Memorandum of Transfer. And the name of the form is normally 14A. Borang 14A, kan? National Code. Okay. So, borang ini, the form 14A, the MOT will be used to transfer the strata title from original proprietor to the purchaser. Now, the developer's M&M can be directly passed on to MC if 25% or more allocated share units have been transferred to the respective share unit owners. Masa nak beli kan ada schedule of parcels kan, kita boleh refer. The purchasers can refer to the schedule of parcels to see the share units allocated on their parcel. So, setiap parcel ada dia punya share unit 100 daripada, for instance, the total of the strata scheme ada 10,000 share units. For one parcel, katakan 100. Okay, and it's equal, katakanlah for the sake of this for this video, ada 100 share units, okay, and then totalnya 10,000, so that means that ada 100 lah kan, ada 100 parcel, ada 100 parcels in the in that particular scheme. So if 25% of the 10,000, it means that 20%, 10,000, 2,500, betul? 2,500 tu berapa title yang boleh yang dah ditransfer, baru boleh kita assume that the next management body is the MC. So we say just now 100 per parcel kan, so kita need 2,500 untuk catatkan 25%. So that means that 2,500 divide by 100, 25 unit tu dah ditukar, dah dipindah milik kepada the new owner. Then only kita kata, oh kita boleh buat FAGM. Then only the first AGM of the MC be conducted. Inilah point dia. But the point is dia mesti dijalankan. The 25% tu must be achieved within the 12 months of the delivery of vacant possession. So dia ada dia punya time the clock tu ada untuk capai 25%. Kalau terlalu lama sangat, developer tak boleh stay on, perlu form the alternative lah, which is the JMB. Ada tak cakap sini? The JMB lah, kalau achieve 25% within 12 months, boleh form MC. Kalau tak dapat transfer 25% of the total share units within 12 months, terpaksa buat FAGM of the JMB. Okay, so ada situation whereby the 25% is likely to be achieved. Ada yang membolehkan 25% within 12 months to be achieved ialah bila the delivery of vacant possession comes together with strata titles, which is what we learn during the lecture on issuance of strata title. Inilah apa yang the current system ataupun government cuba nak ensure. Bila you dapat kunci saja, you dapat your strata title on your name kan. Dia cuba dapatkan ini. So it's likely in this situation, in this scenario, bila serah kunci ialah bersama dengan strata title, the next management body ialah MC. So developer will pass on to the MC if 25% is achieved. 25% of transfer of the strata title is achieved within 12 months. Yeah. Sekiranya if the delivery of vacant possession comes with strata titles. So what are the situations, some of the situations whereby the 25% is unlikely to be achieved ini? Yang mana kalau unlikely to be achieved within 12 months, the next management body will be the JMB, bukan MC ya. When the delivery of vacant possession does not come with strata title, belum transfer. Strata title tak siap, tak issue pun lagi. Contohnya ada delay. maybe the application was was incomplete, ada cacat dalam dia punya documents tu. Ada details yang perlukan, there are details that need to be verified at the PTG yang perlukan masa yang lama. Therefore, delivery of vacant possession does not come together with the strata titles. So ada situations tu. Okay. Untuk complex cases, complex yang rumit, untuk cases yang rumit, ada situation tu, whereby dapat kunci tapi strata title tak transfer kepada nama buyer. So ada cases lain, ada unique cases such as many units unable to be sold, the developer simpan sebagai investment, developer kan, sebab dia tak transfer kan. So inilah kejadian yang mana developer tak boleh terus hand over kepada MC tetapi terpaksa buat JMB dahulu. So what are the duties of the developer under the Developers Management Period, DMP? Again, DMP is when the next management body ialah the JMB. Yeah? Tak berjaya dapat 25% tu. So the duties of developer under DMP are outlined under section 9 sub 2 SMA. So the first one is to determine and impose charges to be deposited into maintenance account. So itu first of all, mesti ada duit untuk buat M&M, untuk proper maintenance and management. So first of all, must determine the amount and then impose. Satu determine maknanya you setkan the amount, you set the charges amount. But on top of, after setting the amount, the amount of charges, the charges must be imposed. Mesti pula dikenakan kepada the pemilik, the strata owners untuk kutip duit tersebut. Okay, so determine and impose charges to be deposited into the maintenance account. The second one is to determine and impose. Sama juga, set dan kemudian kenakan. Determine and impose sinking fund sinking fund contribution to be deposited into the sinking fund account. So kutip dua duit, satu untuk operational punya cost, satu lagi untuk capital kan, punya expenditure. Then effect insurance, perlu dapatkan insurance untuk common property, untuk the building. So effect insurance, developer punya duty. Tak boleh kalau bangunan satu strata scheme tu, the building cannot be without insurance. Nanti kalau jadi apa-apa susah. Fire for instance, ataupun the example I gave in class before, climate change kan, kita ada tornadoes, ada reboot kan, all these things. Ada flood tak masuk kot. Flood is a different one. But fire lah especially. Must be there. You must have fire insurance. Then comply with local authority or other public agency notice for nuisance abatement or works on the common property. Kadang-kadang common property tu boleh mengakibatkan nuisance. Kadang-kadang ada belukar bushes that become the place for mosquitoes to breed kan. Lepas tu pejabat kesihatan datang, the health punya agency datang and then saman ke ataupun bagi notice, keluarkan give a notice for the bushes to be cleared, for all stagnant waters to be cleared on the land. Land is common property kan. So mestilah the developer must undertake the work according to the notice. Kalau suruh clearkan bushes, kena clearkan bushes. Kalau kata kena keringkan stagnant water, kena keringkan stagnant water. Contoh. Okay. Prepare and maintain a register of all parcel owners. Ini tadi register yang on-site tu. Ada strata rule. Okay. Sangat penting ni sebab kita kena tahu siapa. The developer needs to know who are the details. Who are the owners, the contact address, contact number of the parcel owners, their share units as well. Ensure the accounts are audited and provide the audited financial statements to all purchasers. Satu itu, first of all, the accounts pertaining to the charges and the sinking fund just now must be audited. Mesti ada third party coming in and ensure that the money was spent properly. Kalau charges on operational punya expenditure, kalau sinking fund untuk capital punya expenditure and not to be used other than that. Contohnya developer gunakan untuk beautification of something, untuk yang tak perlulah kan, beautification, ataupun amount yang spend tu tak balut, tak correspond. Mana pergi duit? Where does the money go? If we say that we spend 200,000 on beautification of the lobby area, tengok-tengok tak ada apa pun dia buat, dia tak some plants only. So there needs to be an audit of all the expenditure. And not just that, the audited financial statements must be provided. And actually dia present at AGM lah, kalau ada FAGM lah kan, so present kat situ lah. Enforce bylaws. We are going to learn about bylaws later on. So bylaws are, first of all, ada statutory bylaws yang mana wajib set out under the act yang mesti di-enforce, mesti di-follow. First of all, must be followed by all, and then must be enforced. Meaning if there's any breaches, if there's any breach, the developer needs to step in and enforce. Dia perlu ambil tindakan. Enforce means to take action. And then on top of that, dia ada satu general clause, satu general subsection yang katakan the developer must do other things expedient and necessary for the proper M&M of buildings and lands intended for subdivision into parcels and the common property. So expedient maknanya apa yang praktikal lah. Kena ambil tindakan yang praktikal, yang penting, yang perlu for the proper maintenance and management of the building ataupun land intended for subdivision to parcels kan. Ini untuk horizontal strata. And also on the common property. Building means, ingat, buildings tu the sempadan luar tu. Anything inside the half that is on the wall, you can divide into bahagian, the portion that is facing to the parcel and then facing outside kan. So we are now talking about the part of the envelope, the external envelope yang face outside tu, sebab itu building. Kena pergi balik pada definition of building. So that will be under the responsibility of the management body untuk maintain and manage. Now, I'm going to talk in more detail about the duty to prepare and maintain a register of all strata owners just now. Remember the register that must be kept at the management office tu, at the strata scheme itself kan. So this is a register under section 30, section 30 of SMA, whereby it says there, okay, the section 30 register, the developer during the developer's management period shall prepare and maintain a register containing the following particulars of strata owner. So inilah dia punya the register that I was talking about, yeah. So all these details are, the first one, allocated share units assigned to each parcel. So kita kena tahu share units dia, floor area, okay. And then ini owner details, the name and address of every parcel owner, and if the parcel owner is not a resident of Malaysia, the address in Malaysia at which notices may be served to the parcel owner. Kita sometimes we cannot get hold of the parcel owners lah in their overseas address kan, ataupun cost tu terlalu tinggi, prohibitive kalau kata kan, cost terlalu tinggi. So there must be an address in Malaysia whereby we can forward all the communication with the with the owners there. Okay, so this includes, for instance, contoh, alamat macam mana ni, alamat saudara dia ke bukan alamat saudara. We're talking about the solicitors, maybe solicitors office in Malaysia, ataupun the agents kan, office in Malaysia, agent yang handle the purchase ataupun yang menguruskan the investment property of the foreign buyers tu, boleh. Ini normal, this is normal. For instance, we have foreign investors yang beli apartments in Forest City, Johor kan, JB tu, Forest City, in Penang, in Melaka. Sometimes they buy not to stay here, but they buy as investment properties kan. So adalah dia punya agents di Malaysia yang uruskan. So we're talking about those agents whereby we can direct all the mails. Mails means the hard copy lah. Semua correspondence, official correspondence to those people. The name and address of the solicitor acting for the parcel owner in the sale and purchase of the parcel. Okay, penting juga yang yang menguruskan the transfer, the perfection of transfer just now, yeah. And not just that. So satu itu the main responsibility is to prepare and maintain the register, untuk membuat membuat register tu sendiri, untuk menubuhkan, untuk physically create the register. After that dia kena maintain the register. But on top of that, dia kena juga, the developer also, they must treat apa-apa information, all the information contained in the register ataupun all the information received with strictest confidence, dikira PNC, private and confidential, in line with the Personal Data Protection Act 2010. Tak bolehlah simply jual, sell all the data kepada third party. No, ini larang, that it is prohibited under Personal Data Protection Act 2010. So mesti jaga kerahsiaan lah. And also kena maintain lah, termasuk dalam maintain tadi, must update the register from time to time untuk pastikan all the information are updated. So just previously we talked about the duties of the developer. Now we talk about the powers, dia punya kuasa. Now remember, power, whatever is done outside the power is ultra vires, betul? Kawan kita ultra vires tu kan. So we must know the powers given under SMA for the developer during the developers management period, DMP. So the powers are given under section 9 sub 3 SMA. The first one is to collect charges. Tanpa kuasa ini, developer tak boleh lah kutip dia punya bayaran tu untuk charges and also sinking fund. So must be afforded the power to collect charges from parcel owners in proportion to the allocated share units. Basisnya ialah share units. Tapi siapa set the rate? The rate for the charge? Rate kali share units equal the charge kan? Amount of charge. So siapa yang set the rate is the developer. Dia beri kuasa. Macam mana nak set the rate for the charge? Mesti ada budget yang sufficient dulu. Budget tu kena betul. The budget must be correct. Then only you can set the rate. Then the rate times the share unit, you dapatlah the amount, the collection amount for charges for that particular unit or that particular parcel. The second power is to collect sinking fund contributions. Aku kutip duit saja kerja dia kan. So first of all, charges. Second of all, sinking fund contribution from parcel owners. The third one, power to authorize expenditure. Kuasa untuk perbelanjaan, untuk meluluskan perbelanjaan, to authorize expenditure for the maintenance and management of buildings or lands intended for subdivision to parcels. Now again, ini kan lands intended for subdivision to parcel. Ini satu perkataan tau. It's a phrase. Long phrase. Lands intended for subdivision into parcels. Because this refers to again kepada apa? Kepada horizontal strata. Kan? So buildings ni vertical strata lah, the common one. The high rise that you subdivide into strata titles, but there are land parcels yang daripada lot yang you subdivide again kan di dalam lot tersebut. So these are the lands intended for subdivision into parcels. Dia satu phrase. Okay. And also expenditure on the common property, on the lift, on the corridor, on the lobby, on the landscaping, on the itu semualah common property, on the land itself, fence, itu semua common property. So diberikan kuasa untuk luluskan perbelanjaan. The developer is authorized to spend on the buildings or lands intended for subdivision into parcels and also common property. And then another important power is to recover from any parcel owner any sum spent in complying with local authority or public agency per section 9 sub 2 sub D. Ini yang tadi yang nuisance tu, nuisance abatement kan, on the common property. Sekiranya the nuisance comes from a particular unit. Ada banyak kes, unit tu tiba-tiba dibela haiwan. Ada satu kes tu bela kambing dalam apartment. So perlu ada dapat notis sebab dikomplain kepada majlis paksa campur tangan, sebab adalah dia very bad in that case. Ada certain issues lah yang sebabkan aduan kepada MC tu bukan tak layan tau, but adalah isu dia sampai buat aduan kepada third party, which is the local authority. Local authority keluarkan notis untuk abate that particular nuisance Contohnya beli haiwan yang terlalu banyak. Example, keeping of too many animals in the apartment kan. So until the nuisance notice comes from the local authority, not from the management body, sebab terlalu serius contohnya kan. So bila any expenditure on complying with the notice, katakan the MC, the management body pula terpaksa take care of the akibat nuisance je, bau busuk, so dia kena spend a lot lah untuk cat baru ke apa, for the corridor, ataupun for instance to call for sanitization kan of the place, to incur cost. So that amount can be recovered, boleh diklaim, dituntut daripada parcel owner. And then, okay, the developer, okay, must do all things reasonably necessary for the performance of its duties under SMA. Diberikan kuasa juga untuk mengambil tindakan-tindakan yang selama mana munasabah, reasonably necessary, yang mana penting dan munasabah for the performance of its duties. Contohnya contohnya bad behaviour from bad behaviour from residents kan, ada komplain daripada jiran, then tindakan apa yang dia boleh ambil ni? All things reasonably necessary. Contohnya pergi ketuk pintu, contohnya bagi notis, tu contohlah. Now the next section will be on the duties and rights of owners. Now the duties of parcel owners are outlined in the third schedule of the Strata Management Regulation 2015. At the back of the Strata Management Regulations, ada jadual, there are forms, there are schedules, and one of the important schedules is third schedule. Ni third schedule ni outlines all the duties of the parcel owners yang wajib dipatuhi oleh semua parcel owners, tak kira strata, residential strata ke, office strata ke, factory strata ke, semua tu kena patuhi all these duties, ya. So we will look at all the 11 duties of parcel owners, beginning with the first one. The third schedule says there of the Strata Management, Maintenance and Management Regulations 2015. Dia punya pendekat, dia punya the acronym is SMR, third schedule. So outlines the duties of the parcel owners, beginning with number 1, promptly. Ini duty dia. Promptly pay all charges and contribution as well as all other money imposed by the management body. Again, if you notice kan, from my lecture, I selalu mention pasal duit. I always mention about money. It is so important in the proper maintenance and management of any strata scheme. Duit tu segala-galanya. Nobody wants to undertake repairs and maintenance without being paid. Tak ada orang nak buat cleaning tanpa bayaran. Tak ada orang nak buat security tanpa bayaran. So, kalau you jadi property manager later on, inilah dia. Ini semua pasal duit. Mesti ada duit yang cukup. There must be enough money, enough funds for you to properly maintain and manage any strata scheme. Tak kisahlah residential ke, commercial ke, industrial strata ke, must have enough money. And power, duty, semua berkaitan dengan duit juga, ya. Now, first of all, promptly. And the keyword here is promptly. Duty-nya adalah untuk bayar dengan cepat. Dapat saja invoice bayar, dapat invoice bayar. Otherwise ada tindakan boleh ambil. First of all, boleh kenakan interest kalau lambat bayar, ya. Okay, and all other money. Again, all other money tadi kalau denda, interest tadi, lambat bayar, so ada interest kena bayar about katakan 8% per day. Bayarlah the interest imposed by the management body. Then again, money matters, duit lagi. Pay all taxes and outgoings in respect of his parcel. So selain daripada bayar charges and contribution just now to the management, kalau ada any other taxes, ada cukai petak, parcel tax for instance, parcel tax pula, cukai petak, parcel tax, parcel rent, ada lagi indah water, ada lagi apa cost lain lupa dah. Utilities tu sendirilah kan responsibility. But the important ones, indah water. Kalau indah water tak bayar, nanti susah untuk untuk apa? For the whole scheme tu untuk dia, sebab dia comes together satu. Kalau ramai orang tak bayar nanti affected the service by indah water services. So kena bayar dan diwajibkan by third schedule of SMR supaya kita bayar all the taxes and outgoings. Then the next one ialah this one. Ya. Another duty ialah untuk let ataupun permit. Permit the management body, sama ada JMB, developer, MC, or its agents or servants, ataupun worker dia, ataupun dia punya agent, maknanya contractor dia lah yang telah dilantik, agents or servants, to access the parcel, untuk memasuki petak tersebut upon notice. Maknanya mesti dapat notice. Owner bila diberi notice untuk management body ataupun pekerjanya masuk, dia mesti benarkan masuk. But for these purposes lah. First of all, untuk investigate leakages, the second one to undertake repairs and maintenance of the common property, diperlukan access to the, for instance, the fasad rosak, tapi perlu gunakan parcel tu untuk tengok ke fasad kan. So perlu benarkan, the owner must let the management body or its agents to come in to the parcel to look at the common property tu. Common property tu bangunan, the permukaan bangunan tu lah, fasad. Kadang-kadang you boleh repel daripada top of the building pakai tali kan, but sometimes dia just nak check dulu kan, dia tak perlukan sebab bahaya kan, to repel down using the rope, using a rope. Kadang-kadang dia kata nak tengok dulu kan, so dia nak perlukan access kepada unit you untuk tengok keluar daripada balcony contoh. So you must let, tapi first of all mesti bagi notice dulu. Then to execute any work or act in relation of its duties. For instance, nuisance tadi tu dapat notice kan, dapat sama ada complain from next door neighbour ataupun dapat notice daripada local authority. Ada orang terus pergi ke local authority complain pasal nuisance. Ada orang simpan 30 kucing kan dalam dia punya apartment. So terus saja management body boleh inspect that particular parcel yang dapat complain tu, tapi bagi notice dulu. Okay. Then carry out any work as ordered by any public or statutory authority, apa-apa sajalah yang perlu dijalankan. Contohnya dia dah the owner has carried out extension. Tiba-tiba dia tambah balcony pula kat dia punya unit, which is illegal kan. Ada orang buat very creative. First floor tiba-tiba ada beam kat luar, lepas tu dia buat balcony baru. Lepas tu dapatlah notice, demolition notice from local authority. You must demolish. Then must demolish the extension, the illegal extension just now. Yeah. Repair and maintain his parcel. Again, the responsibility to maintain and manage untuk parcel tu adalah on the parcel owner, him or herself. Okay. Apa rosak, you must repair yourself, maintain. Now, what about the next one? The next duty, which is to maintain all sanitary fittings. Sama ada sanitary fittings tu berkenaan dengan sewage ya. So termasuklah pipes and apparatus, so as to avoid causing fire, explosion, leakages or annoyance. Sewage dan juga kitchen, don't forget kitchen tu ada pipe kan. You basuh pinggan, or when you wash the dishes or when you cook kan, you use the kitchen sink. Water from the kitchen sink must go somewhere, right? So ada pipes kan. Ada case baru ni, they use the drain, pipe cleaner meletup orang bawah punya pipe ya. So you must use your pipes in such a way that doesn't cause any damage to other people lah, or nuisance. Jadi pula macam tu. Don't buy things online. Boleh jadi akibat macam-macam. We never know kan what can happen to the, dia pakai apa chemical, I forgot. But you just pour the chemical. Dia macam serbuk kan, I'm not very sure whether it's liquid or powder. You just pour into the kitchen sink. Sekali orang bawah tu meletup dia punya pipe. Tak boleh. Now, repair his damaged parcel if the damage is not covered by the MC insurance, the management corporation insurance ataupun management body insurance. Kalau katakan ada small fire kan, small fire ataupun katakan apa contoh lain lagi, macam-macam contoh lah can be damaged but fire is the most common one. Masak telur, masak Maggi lah biasa. Masak Maggi and then forgot to keep a watch lah on the Maggi. Sekali rentung habis asap satu dapur. In the whole house smells of of smoke ataupun in the kitchen you can see dia punya asap tu kan, the hitam one, the black soot from the burnt Maggi. Dah ada terbakar sikit curtain ke apa, then you must repair the damaged parcel. Not use or permit to be used the parcel or cause danger or nuisance. So sometimes the most common one is pet keeping lah, animal keeping. Tiba-tiba dia simpan animal banyak-banyak, or not just that, sometimes dia use ada juga ni case, but this is what I've heard before, is not does not involve strata, tapi ada residential house, dia buat simpan gas, gas apa nama tu, tong gas kan, sebab dia buat business. Kot lah ada ground floor punya owner, strata owner, dia buat business kedai runcit, itu dia punya unit, lepas tu dia simpan. Tak apalah kalau if it's ground floor shop is fine, but if it's a flat kan, ground floor yang supposed to be used for residential, lepas tu dia convert jadi kedai runcit mini, lepas tu letak pula dia stokkan gas untuk neighbor dia nak beli gas masak-masak, suddenly run out of gas, want to buy from him, itu semua boleh cause danger kan, meletup ke apa kan, when it's not meant to be the unit is, or the parcel is not meant to be a shop kan, so tak boleh, cannot use or permit to be used the parcel to cause danger or nuisance. Then not use, ni pun sama in relation to my example just now, not use or permit to be used, not use or permit to be used the parcel contrary to the approved use. Apartment residential punya parcel being used for commercial, dia buat kedai or dia buat office, cannot. Notify the management if there is any change in proprietorship for subsale kan, from the original purchaser dijual kepada subsequent purchaser. Kalau ada perubahan, if there's any change in the proprietorship, must inform the management. Hari tu I had to give a copy of my SMP to the management office to make sure that the new name, the new owner's name is on the section 30 punya strata roll tu, kan. Sebab management body kan ada responsibility to maintain the strata roll, section 30 punya strata register tu kan. So kita tolonglah dia. So we must notify the management if there's any change in the proprietorship. And finally, use and enjoy the common property in a way that does not impede on other proprietors' use and enjoyment of the common property. Ini selorong buat. Tiba-tiba saja koridor tu dia claim ini kawasan rumah dia, dia bina permanent structure or even choke parking kat depan rumah dia ke. Itu common property, not supposed to be used for individual parcel owners, must be shared together. Okay. Banyak lagi case, tiba-tiba dia buat store kat depan, dia letakkan apa nama tu, what do you call that, metal punya grill, dia buat satu kepung, dia buat 3D 3 petak kan, dia lekat sekali dengan dinding, dia punya pasal kat luar dekat koridor, ini store dia untuk kasut dia contohnya. Tak boleh lah, cannot. You cannot, must use the common property in a way that does not impede, yang tidak menghalang orang lain. Okay, after all it's common property. Now we're going to discuss about the obligation or of the duty of the parcel owners to pay maintenance charges, okay, to the developer. Ini the initial period tu, where the developer is in charge of M&M, okay. And we have to distinguish between residential strata and non-residential strata because the treatment is different. Untuk residential, for residential strata owners, okay, their obligation, the duty to pay is based on the Housing Development Act, okay, or in this case, more particularly the Housing Development Regulations 1989 lah, okay. But for the non-residential strata, it's based on something else, contract. Sebab dia tak ada Commercial Property Act kan, Development Act, dia tak ada kat Malaysia. So we only have Okay, an act to control for housing development sahaja, for residential development only. Okay, so first of all, for residential strata owners, says there, clause 19 of Schedule H. Schedule H tu apa? Is the SMP for strata property kan. Okay, so clause 19 of Schedule H of Housing Development Control and Licensing Regulations 1989, okay, it states that the purchaser must pay to the developer the charges and sinking fund for the maintenance and management of the strata property. Wajib bayar. And this is applicable to new strata property. Okay, and for subsale, meaning for subsequent transfers ataupun subsequent purchase, okay, between the first buyer just now with to subsequent buyers, okay, the purchaser can apply for the statement of account of the parcel intended to be purchased. Kalau you lah later on, you nak beli subsale, okay, jangan terus beli, you have to check the debts. Tengok dulu ada hutang ke tidak. You must check whether the parcel has any debts in terms of payment. Tak bayar, arrears. Arrears nama dia, bukan debt. Any arrears in terms of payments. Okay. By way of asking, mesti minta statement of account. It's a very specific document. It will outline all the debts, all the arrears. Bukan debts. Debts tu hutang biasa. We're not talking about arrears. Tunggakan. Statement of account of the parcel intended to be purchased. The management body, when we ask for the statement of account, the management body must wajib give the info within 21 days. 3 minggu. Dalam masa 3 minggu, management body mestilah memberikan information about the accounts just now. Otherwise, kiranya tak beri, liable to be fined not exceeding 50,000 ringgit or imprisonment not more than 3 years or both. Sangat serius benda duit ni. So, but the onus, the burden, the onus maknanya the obligation is on the buyer lah, the future buyer untuk pastikan dia minta statement of account. Kalau dia tak minta, macam mana orang nak tahu dia nak beli? Macam how can the management body knows that someone is intending to buy kan? You mesti minta dulu account tu daripada dia. You must ask for statement of account from the management body. Okay. It's your responsibility to know what you're buying into. Ada hutang ke tak ada hutang? Ada, you have any tunggakan, not hutang. Any arrears or no arrears? Oh, sebenarnya hutang lah sebab there could be other monies have payable other than arrears. Interest, for instance, lambat bayar, interest akan berjalan kan? Interest on late payment. Okay, so here, okay, again, this is quite important. First of all, kena tahu. You purchase, if you are a buyer, you're not the owner yet, kan? You mesti first of all get your name on the strata title, barulah you jadi owner. But before that, okay, make sure that you buy a good property lah. Make sure you know beforehand what are the obligations. Sekiranya you terbeli property yang ada arrears, it's your responsibility, unless lah you dapat satu lawyer yang bagus who can pursue for you. You can pursue the original the payment from the original purchaser tu, the first purchaser. Tapi tengoklah, kan sometimes jaya, sometimes tak jaya. Okay, so sometimes lawyer tu pun tak aware. Now this a good solicitor will be able to advise you on this. Dia yang akan make sure that you get this statement of account of the parcel that you intend to buy. Now, for non-residential, again, treatment is different. Dia tak ada satu akta yang katakan inilah dia punya obligation to pay. The obligation is based on contract. Obligation to pay charges and sinking fund is based on contract untuk bayar kepada developer. And then the amount payable is determined according to provisional share units. Kalau sekiranya belum lagi sah, belum ada title, then the share units is provisional, sementara. Okay, siapa yang tentukan the share units? The developers licensed land surveyors. Okay, and now this is quite important as well because of the fact that it's the initial period of management and maintenance. Okay, perlu duit yang banyak pada awal tu lah. Okay, so the charges and sinking fund amount are for the first 4 months in advance. Masa mula-mula tu, during the developer punya period kan, developers management. Okay, you must pay upfront 4 months and thereafter, selepas itu barulah monthly. You bayar monthly in advance, maknanya katakan for the month of May, you pay in April. Pay in advance, sorry, you pay early in the month. Bukan April lah. You bayar 1 hari bulan, 2 hari bulan untuk maintenance for the month of May. You tak bayar akhir bulan. Bila semua ni dah berjalan, you mesti make sure that the money is there to pay for the expenses. Okay, that is the logic behind it. Now, very briefly, okay, the voting rights of parcel owners according to the second schedule STA. Okay, you have show of hands, angkat tangan, show of hands or poll. So if the voting type is by show of hands, you only get 1 vote per owner. But if the voting type is by poll, okay, you buat undian melalui poll is undi lah, melalui undi tu, melalui kertas undi, okay. It is the voting right per owner is corresponding with the number of share units. So lagi banyak share units, the higher your voting rights. Okay, provisional. So in the case of new share units yang belum lagi ada strata title, is based on provisional share units. Yeah. And then it says that owner is not entitled to vote and be elected to hold office at an AGM unless all contributions to the management fund in respect of his parcel or provisional block have been paid. Kalau ada hutang, sinking fund, hutang charges, then he cannot vote. Tak boleh, mesti zero balance. Now, general prohibitions are certain restrictions lah, that are applicable to all parcel proprietors. So what are some general prohibitions to a parcel proprietor? So these are outlined by Regulation 9, okay, third schedule SMR, okay, some of the prohibitions. The first one, the parcel owner or parcel proprietor cannot use his parcel for any purposes, which could be illegal, which could be legal, which may be injurious to the reputation of the building. Injurious to the reputation maknanya merosakkan nama baik. Injurious to the good name, to the reputation lah, reputation, good name lah of the building. For instance, for vice purposes lah, jadi sarang sarang pelacuran ke kan? May I say that? Yes, vice kan, digunakan untuk tujuan yang illegal, yang menjatuhkan nama baik ataupun menjejaskan nama baik of the building. That is prohibited. Use as fuel any substance or material which may give rise to smoke or fumes or obnoxious smells. Ini kadang-kadang adalah, kadang-kadang ada some people who burn incense, for instance. Incense tu colok kan. Incense excessively, terlalulah banyaknya incense sampai mengganggu kan. So tak boleh, dia kata. Or use as fuel, menggunakan bahan bakar yang busuk, yang boleh ganggu orang, yang boleh menjejaskan kesejahteraan kan, that can affect the well-being of other strata owners kan. That is prohibited as well. Then, okay, this is quite important and happens. Throw or allow to fall any refuse or rubbish on the common property except in refuse bins maintained by him or in refuse chutes provided in the building. Larangan buang sampah dari atas. Okay, throw or allow to fall any refuse or rubbish. So this, inilah video that I provided in Spectrum tu. What happened daripada tingkat atas dia pergi buang plastik makanan tau, ke atas common area kat bawah tu, which is very bad, very bad sebenarnya. And some of the things that are thrown, some of the rubbish ataupun refuse thrown from upper floors tu boleh akibatkan injury, can cause injury, can even cause death. Contohnya buang kerusi, ada pula buang kerusi daripada tingkat atas. A number of years ago, several years ago, ada orang buang bangkai daripada tingkat atas, pun happen. Not to say lah yang biasa-biasa tu, yang normal cases, people throwing their cigarette butts for instance kan, puntung rokok, ada buang plastik, ada buang tisu, tu semua tak boleh, under Regulation 9, third schedule. Okay, due to the fact that strata developments normally involve many people being together at one place kan, at one time, can be living ataupun working kan, for what you call it, for commercial strata ataupun to shop together for retail strata kan. So there must be some guidance lah ataupun some regulations lah pertaining to nuisance. So regulation 10 of the SMR contains prohibition to owners related to nuisance, which is first of all not use language or behave in a manner likely to cause offence, embarrassment or nuisance at the common property. Dekat lobby for instance, tak boleh menggunakan bahasa kasar, tak boleh behave in a manner yang tak which is socially unacceptable, that can cause offence, yang boleh sebabkan orang rasa offended ataupun embarrassed, malu, pakai baju seksi for instance kan, manner atau behaviour lah, ataupun buat sesuatu kelakuan yang jelek lah, kata tidak boleh sebabkan offence, embarrassment, nuisance. Tak boleh menjerit-jerit for instance in the lift lobby. Sudah ada this regulation. Second one, ensure invitees. So invitees orang yang dijemput, jemputan. Ensure invitees do not use language or behave in a manner likely to cause offence, embarrassment or nuisance at the common property. So bukan saja owner, not just the owner that cannot behave or speak in a way that can cause embarrassment ataupun offence ataupun nuisance just now, but the invitees pun, orang yang dijemput, jemputan, kadang-kadang family members or friends datang ataupun nak buat party ke kan, at the lobby itself, at the common area, dekat near the swimming pool for instance, kalau ada, tak boleh behave in a way yang boleh cause nuisance ni. For residential strata or part of the strata scheme used as dwelling, ini prohibition, larangan bunyi bising after 11. To keep at low volume after 11 PM the sound of any electric or electronic equipment, apparatus or appliance or musical instrument used in the parcel or common property. After 11 PM, you cannot tumbuk lesong batu. You cannot use your mortar, pestle tu kan, tumbuk sambal. No, that is not allowed. You cannot, for instance, tiba-tiba nak main drum, practice your piano ke after 11 PM, that cause so much noise kan. Dia bukan music, noise sebab baru belajar. Okay, or do DIY, masa tu lah dia nak buat DIY shelf, nak install shelves in the living room, you ketuk dinding, is prohibited. Now, not use, and this was from before, not use any fuel, substance or material or do anything in his parcel that interferes with the peaceful enjoyment of other owners or cause discoloration of his or other parcels. Tak bolehlah guna untuk sebarang bahan bakar, fuel ataupun bahan-bahan atau material yang boleh akibatkan ketidaktenteraman, that interferes with the peaceful enjoyment of others. Cause discoloration of his or other parcel, mengotorkan pula dan mencacatkan pula the dinding ataupun the ceiling of other parcels. So what is the precaution that can be taken by the new buyer, subsequent buyer, to avoid from being burdened by the previous owner's debt? Okay, selain daripada just now the asking for the statement of account kan. So this is a way provided under the act, which is new owner is not liable to pay for the costs and expenses owed during the previous owner's ownership. Sekiranya if before buying the parcel, the new owner has made a written request to the management body asking about the recoverable amount by the management body, and the management body has certified that there's no recoverable amount, or the management body fails to reply to the written request within 14 days. So selamatlah. Sebab you dah minta the statement of account, lepas tu management body verify, oh tiada tunggakan, no arrears, so that's fine. Or management body fails to reply within 14 days, then you are safe from being burdened by the debt of the previous owner. But mesti bagi request in writing, written request to the management body tu, asking for the recoverable amount, the statement of account, the account. Now, if the new owner does not take care, sekiranya tidak buat, does not take care to ascertain the owed amount before buying, the new owner is likely to be liable for the outstanding amount. That itu transferred, could be transferred to the new owner. Dia lah terpaksa tanggung, dia lah terpaksa bayar the debt. Mungkin. Okay, unless dia boleh prove dia telah ambil tindakan yang di atas ini.
So the final part of this video will be on bylaws. Now, I have mentioned before that all parties have to obey the bylaws within the strata scheme. So the bylaws that I mentioned here are bylaws specifically for the strata development. Per the act lah. Bukan bylaw UBBL ke bukan. Ini specific bylaws pertaining to strata development. So what are bylaws? Undang-undang kecil. Bylaws are special laws under SMA that provide standardized rules and regulations for whom? Untuk siapa? For developer, management bodies, purchasers, owners, tenants, charges, lessees and occupants. Semua sekali tertakluk kepada bylaws. All these parties must obey the bylaws. And the bylaws are standardized for all. Semua type, for all types, all locations, tak kira di Malaysia. For types horizontal ke, vertical strata ke, residential ke, commercial ke, industrial ke, all of the strata developments are controlled or regulated by the bylaws. Mesti pakai bylaws ini. The bylaws regulate the management, administration, use and enjoyment of the building and land intended for subdivision into parcels and the common property or limited common property. So bylaw ini dia control management, administration, use and enjoyment of the strata development. Termasuk semua sekali lah. Termasuk building, termasuk common property, termasuk land intended for subdivision into parcels. The horizontal strata just now, ya, semua tertakluk kepada bylaws. And the bylaws are contained in the third schedule of Strata Management Regulations, SMR. Jadual ketiga. Now, besides the bylaws, besides the undang-undang kecil, there are additional bylaws. So, ada two types of bylaws. One, okay, the bylaws yang standard. The second one is additional bylaws made and approved during the general meeting and are not contradictory to the prescribed bylaws that also must be obeyed. So maknanya dia ada prescribed bylaws. Prescribed tu maknanya yang standard punya, standard bylaws per third schedule SMR. On top of that, because each of the strata scheme in Malaysia may be different, may be unique, they may need specific or additional bylaws to top up, to take into account the differentness ataupun the requirements, the unique requirements of the strata scheme. So they can pass additional bylaws in their general meetings. So this shows you the overview of the bylaws as contained in the third schedule SMR, beginning from introduction. Part 1 is introduction applicability, and then you have the function, duties and responsibilities of the management bodies. Under part 2, duties of strata owners. Part 3, rules and regulations of the use and care of common properties. Part 4, part 5, rules and regulations of parking protocols pun ada. Part 6, proper disposal of solid waste. Part 7, rules and regulations on renovation works. Part 8 provides power to the management body to act and handle proceedings as agents for proprietors for inter-unit defects. So complete, it's comprehensive, yeah. May not be 100% complete, but as you can see, semua pun ada, from the duties of management bodies, duties of strata owners, apa lagi, the common property, apa rules and regulation, apa boleh buat, apa tak boleh buat in common property. Parking pun ada tu, regulations pun ada. So actually the third schedule of the SMR 2015 is core to the selain daripada duit lah. So in ruling or in controlling the use of the, and also controlling the not control, to impose the duties on the respective parties. Everything is referred to the third schedule SMR. Now, examples of bylaws. What I want you to do is I want you to freeze, okay, this slide and the next slide, okay, and then read, yeah. Make sure you read the examples of the bylaws for the management body, for strata owners, and then for the that pertain to all parties, yeah. Freeze and read.
Now, as mentioned before, on top of the bylaws, their standard bylaws, or otherwise known as prescribed bylaws, under third schedule, okay, boleh juga the strata development or strata scheme can also have their own additional bylaws, okay, because each strata development can be distinctive. Dia boleh jadi lain, dia ada own characteristics. Contohnya number of units lain, ada yang banyak, ada yang sikit. Okay, some may have swimming pool as their common property, ada yang tak ada. Okay, and then in terms of size, ada yang besar, ada yang kecil. Okay, so additional bylaws in writing are needed to cover specific situations that may arise due to the unique nature of each strata scheme just now. Okay, so perlu boleh can make additional bylaws. Additional bylaws are additional rules and regulations created by the managing body in order to cater for specific situations unique to that particular strata property. It says they're managing body. Managing body termasuk ke developer? Yes, but only untuk developer under DMP. Kalau PMP, that developer tidak boleh buat additional bylaws. Additional bylaws are allowed under section 32 and 70 of SMA, tetapi must not contradict the prescribed bylaws. Prescribed bylaws tu yang standard lah, standard bylaws under third schedule. So boleh buat, but cannot contradict the prescribed bylaws. Additional bylaws can be made by GMB-MC, also sub-MC, by passing a special resolution. Okay, boleh buat. Special resolution pass di mana? Pass di general meeting. Maknanya general meeting adalah semua owners akan sit down together. But not only make the additional bylaws, boleh juga amend the additional bylaws. Amend includes to revoke. Boleh juga untuk batalkan the additional bylaws. Now, my point just now, what I mentioned just now, developer boleh. Developer is allowed to make additional bylaws during DMP but not under PMP. And developer yang under DMP, when they make the additional bylaws, the bylaws must obtain approval from COB. Because developer pada masa tu belum ada cukup, belum boleh create general meeting lagi. Sebab belum ada cukup quorum, belum ada cukup penduduk, belum ada cukup owners untuk hold a general meeting. So who will check sama ada contradict atau tak contradict? It's the COP. Owner belum ada lagi masa tu. Now, additional bylaws cannot prohibit or restrict parcel dealing. So walaupun you buat, you are allowed to do or to make additional bylaws, tetapi the additional bylaws dia tak boleh restrict parcel dealing. Dia tak boleh kata, oh, kalau you nak jual perlu kelulusan daripada MC, daripada JMB. Tak boleh. That is restricting dealings. Tak boleh. Okay. So transfer, lease, charge, itu semua tak boleh buat restriction baru under additional bylaws. And cannot destroy or modify any easement created under STA. Contohnya, easement yang telah created for cross wall. Tak boleh lah untuk destroy atau modify. Sebab perlu untuk kesinambungan, needed for the continuity of the strata scheme. Now, the procedure to create additional bylaws, first of all, must call for a general meeting. Okay, general meeting itu mesti dibagi notice, must be given notice 21 days prior. Dia mesti bagi 3 minggu, notice 3 minggu. The notice must specify the proposed special resolution for the additional bylaws or amendment of additional bylaws. So dalam notice itu perlu ada satu statement that says that the purpose of this, one of the resolutions to be passed in this general meeting is to make or to amend additional bylaws. During the general meeting, the special resolution must be passed. Mesti diluluskan with a majority not less than 3/4 of the valid votes cast by a show of hands or by poll. So ada dua cara yang dibenarkan. Two methods of voting. One is by show of hands, the other one is by poll. But then the valid votes, kalau angkat tangan, kalau ada 100, if there's 100 owners in that particular strata scheme, 3/4 meaning kalau 175 lah. at least 75 hands must be raised. Itu baru valid lah. Dan baru luluskan the special resolution. Pula you look at the share units. Share units tu daripada aggregate share. So aggregate share unit, my example just now 10,000 aggregate share 10,000 aggregate share units. You must obtain at least 10,000 7500 lah, 7,500 daripada keseluruhan 10,000 share units. Barulah lulus. Then only the resolution, the special resolution will be passed by the meeting. Upon passing the special resolution, the management body shall, first of all, keep a copy of the additional bylaws. Simpan di pejabat dia for reference later on. Then, a copy must be filed with the COB. Mestilah diberikan satu salinan, difilekan satu salinan di COB for JMB within 14 days from the passing of the additional bylaws, whilst for the MC sub-MC within 30 days from the date of the passing of the additional bylaws. So ada beza di situ. Tempoh masa yang diberikan. JMB within 14 days, MC or sub-MC 30 days. JMB tu ada lagi developer. That's why nak kena cepat bagi kepada COB. Now, I want you to freeze this slide, okay, and read the examples of additional bylaws. Okay, we have bylaws just now. We have bylaws, we have additional bylaws. Okay, and we say that everyone, developer, owner, chargee, itu semua tertakluk dengan bylaws and also additional bylaws. So what happens when the bylaws are breached? Bila dilanggar, the bylaws or additional bylaws are breached. Now it says that in case of breach of bylaws, enforcement actions can be taken by the management body. Bolehlah ambil tindakan atas pelanggaran tersebut, enforcement actions. Now enforcement is provided again, untuk take action mesti bagi kuasa. Okay, so here enforcement is provided by sections 125 to 141 of SMA and also the third schedule SMR. Okay, now these are some of the enforcement actions. Okay, the first one is very common. See there, untuk defaulters. See there, the first one, display. First of all, the enforcement against defaulters can display the defaulter list, deactivate access card of defaulters, stop or suspend defaulters from using common facilities, etc. Because after that, itu semua initial baru tau. The first steps that can be taken against defaulters. Selepas itu ada lagi boleh ambil tindakan lain, pergi COB, bawa ke strata tribunal, take action in the court. Banyak lagi dia punya steps yang boleh ambil. Okay. But that's the most common pelanggar breach, because the first duty is to pay kan the charges and the contribution, tak buat. So adalah dia punya tindakan enforcement. Now the second one, okay, require any person who despite being cautioned dah diberi amaran persist in breaching any of these bylaws or additional bylaws to leave the common property immediately. Tadi tu yang larangan untuk behave in an indecent manner ataupun mengeluarkan kata-kata yang tidak yang mengganggu ketenteraman kan. Dah bagi warning, buat lagi. Bolehlah minta orang tersebut sama ada the owner ataupun the invitee tu leave the area, leave the common property. And then require any person on the common property to identify himself for security purposes. So ini hak yang diberikan. Kalau tak bolehlah kata siapa, who are you to ask me who I am. You tak kenal ke saya siapa, saya ni datuk apa kan, no. Sebab untuk security reasons, Pak Guard tu, the security people can ask for identification from you. Untuk pastikan you ni betul-betul lah siapa tu yang you kata. Any person who refuses to comply and is not a strata owner may be asked to leave the common property or strata property area immediately. Because sometimes ada banyak je case, walaupun guarded community, sometimes orang luar masuk and burglarize ataupun apa lagi, ada juga case kecil-kecil curi tu curi ini, curi the parcel ke happens, ya. Require any remove or confiscate any property of strata owner units that obstruct the fire escape routes without prior notice, and the strata owner shall within 14 days of notice claim the property with payment of not more than RM200. Now sometimes fire staircase tu kan sepatutnya tak ada obstruction, barulah boleh lari. Then only you can run down during fire kan. Tapi some people, some strata owners, what they do is they make the fire punya landing tu, the staircase tu, the landing of the staircase tu sebagai store dia. They put the unused furniture, broken furniture, they put their mattresses, old mattresses, dia letak kat situ. Okay. Some cases dia letak bicycle pula dekat staircases, dekat fire escape tu. Tak boleh, obstruction. Okay. So, management body can confiscate, dia boleh remove, buang saja ataupun rampas. If you want it, okay, you bayar denda, not more than RM200. And then okay, again, this is quite important, and you may say, tapi nampak je orang langgar, tapi ini rule dia, ya. This is the bylaw. Clamp and auto any vehicles parked outside the designated car parking bay without prior notice. You parking saja outside the accessory parcel, parking saja outside the visitors parking, itu dah dikira sebagai outside the designated car parking bay. So, you punya kenderaan, okay, boleh di clamp, satu. Boleh di tow, ditunda, tu dia. And kalau nak removekan the clamp, okay, you can remove with the payment of not more than RM200. Ini semua income kepada management body sebenarnya, denda-denda ni, okay. But you know, these are the powers given sebenarnya to the management body. Tak boleh juga pula kita nak question, nak query, who give you this authority? Inilah dia, given by SMA and also SMR. Now, finally, okay, this is a good reminder, okay, for any, for everyone lah, everyone on a strata scheme, okay, that ignorance of the law is no excuse. Walaupun kata saya tak pernah baca pun, I've never read, I've never come across the third schedule of SMR, tak boleh. Ignorance of the law is no excuse. And this doctrine states that the law imputes knowledge. Dia assume, dia letakkan responsibility tu. Imputes knowledge of all laws to all persons within the jurisdiction, no matter how transiently. Maknanya, kalau ada foreign visitor, ada turis datang, okay, datang ke suatu strata scheme, okay, dia kata saya tak tahu pun you ada third schedule, saya pun tak tahu you ada itu Strata Titles Act, dia kata kan. No, dia kata di sini the doctrine states, however transiently, walau sementara mana pun you datang ke Malaysia, walau sementara mana pun you datang visit ke strata property tersebut, you are bound by all these rules and regulations. The law assumes everybody to know the law, and one cannot use the defense of ignorance. I don't know, I'm not aware, is no defense. Tak boleh gunakan itu sebagai pembelaan. And then the law applies to even someone who is not a permanent resident of the area. Tadilah foreigner kan. Saya tak tahu pun you ada Strata Titles Act. Saya tak tahu pun you ada Strata Management Act. It's no excuse. Now, so having said that, ini lastly, okay, now we can see here, in case of any breach of bylaw or additional bylaw, enforcement can be undertaken. Enforcement by whom? By the management body. And then if there is compliance, habislah. Compliance means ikutlah, patuh arahan daripada management body, then it's fine. Okay, when someone makes tadi tu yang berkelakuan behavior, indecent behavior in the common property, at the common property, lepas tu ask to leave, dia leave. Okay, that's it. Yeah, stop lah, full stop, end of action. But if there's no compliance, okay, bolehlah pergi ke Strata Management Tribunal. Okay, and that's all. Okay, the video, okay, on owners and also developer. So recap. Okay, these are the learning outcomes. You should be able, at this point, you know the roles of developers and owners. Understand the duties and powers of developers. You should be able to understand the duties and rights of strata owners. The third schedule just now, yang kita discuss in detail, those contain all the duties, powers of developers and owners. Okay, that's all. Thank you very much.